Добрый день, уважаемые коллеги и гости.
Distinguished colleagues, good afternoon. May I declare the dissertation meeting open to review the dissertation by Tatyana Krasnova submitted in compliance with the requirements for the candidate of law in the subject 120003 civil law, business law, family law, private international law under the title of coercion and autonomy of will and servitude law. Under the relevant resolution of St. Petersburg State University 4015/1 as of April 1927, amended on May 10/27, under the number 4803/1, me, Daniel Tuzov, was appointed chairman of this dissertation board meeting. May I introduce my colleagues, members of the dissertation board: Gabriele Crespi, Doctor of Law, Professor, St. Petersburg State University Civil Law Department; Alexei Skvortsov, Doctor of Law, Counselor of the Constitutional Court; Irina Yemelkina, Doctor of Law, Mordovsky State University by Ogarev; Frederick Zoll, Dr. Habilis, Professor of Jagiellon University, Krakow; Professor of Osnabrück University, Dr. Honoris Causa of the National University of Ternopil. So none of the members of the dissertation board are online with us. First and foremost, may I note that according to federal law as of August 23, number 123 FZ, on the academic degree awarding procedure, the St. Petersburg State University has been granted an exceptional right to award academic degree. A relevant decree was published on September 1, 2016, number 6821/1. Herein a decree. According to this decree, the dissertation board meeting is legitimate unless no more than 4 people are participating in the dissertation board. So the quorum is here. The composition is 5 members. All the 5 members are here, so the quorum is here once again. As I said, the time framework is as follows. The overall meeting must last 2 hours maximum. First point of the agenda, brief report of the chairman on the documents submitted by the defendant in compliance with the requirements, and Q&A session to follow 5 minutes. Second, a brief report of the defendant on the findings of the research. 15 minutes maximum. Questions to the defendant. This is point 3 of the agenda. 2 minutes maximum per questions and the defendant's replies. Fourth, the reports submitted to the dissertation board covering just general questions, questions to the defendant, so on and so forth. 5 general commentaries of the members of the dissertation board, 10 minutes maximum per member. The chairman is the first to perform this statement. The chairman also reads out the external reports. 6. The defendant's reply to the critical commentaries of members of the board. Next, open discussion and statements by members of the audience who are not members of the board. Strictly relevant suggestions are accepted only. 5 minutes maximum per each speaker. All those willing to speak who are not members of the dissertation board have to register in the registration list beforehand which is on the first table. And before you take the turn, please introduce yourself. Next, point 8. Defendant's reply to statements of the audience, 5 minutes maximum. 9, statement of the research supervisor, 3 minutes maximum. 10, 5 minutes break before open voting on awarding the dissertation with the inspired academic degree in St. Petersburg State University. The discussion between members of the dissertation board is not broadcast online. 11, open voting by name, count of vote by the chairman, and registration of the voting results in the protocol. 12, decision-making of whether the defendant has passed or failed. And finally, lastly, 13, concluding statement by the defendant, 2 minutes maximum. Please observe the time framework. Well, before we start the implementation of the agenda, may I urge everyone to switch off their mobile devices. Thank you for compliance. May I also inform you that we are having audio and video recording of the meeting broadcast live on the website of St. Petersburg State University. Simultaneous interpretation from Russian into English and vice versa is also provided. So may I enjoy my title of the chairman and declare the meeting of the board open. Point 1, the report of the chairman. The dissertation submitted by Tatyana Krasnova in the subject 120003, Civil Law, Business Law, Family Law, Private International Law, under the title Coercion and Autonomy of Will and Servitude Law, has been accepted for defense according to the resolution of the Secretary on April 24. Under relevant number, the dissertation board in its composition has been affirmed under the resolution 4015/1 as of April 19, 2017, amended on May 12, 2017, the resolution number 4803/1. The composition is as stipulated before. The defendant has submitted the following documents to the Expedite Center of St. Petersburg State University. First, application addressed to Professor Rector, Mr. Kropachev, on accepting the dissertation for defense, submitted on March 24, 2017. The certificate of the Federal Budgetary Institution of the Higher Education, St. Petersburg State University, as of September 27, 2016, under a relevant number 34435, certifying that Tatyana Krasnova, as of November 1 until now, is a full-time postgraduate in the subject Civil Law, Business Law, Family Law, Private International Law. She has successfully passed 3 exams in Philosophy of Science in the relevant subjects and the foreign language. Number 3, the report of the Research Supervisor, Docent, Professor of St. Petersburg State University, Mr. Rudo Klas. 4th, a list of research papers reflecting the key findings of the dissertation, including articles in the list of the Higher Attestation Commission, Ministry of Education of Russian Federation. 5, the copy of the diploma of the issued by St. Petersburg State University, registration number 212134, issued to Tatyana Krasnova, qualifying her as a Master of Jurisprudence. 6, the dissertation in Russian and in English in hard and soft copy as a manuscript. The dissertation is drawn according to Russian standards, in particular GOST standards. It is printed on a printer and has all the publishing data in it. I should note that all the aforementioned documents are in compliance with the provision 12 section 1 on the PhD awarding procedure in St. Petersburg State University. Now may I proceed to the next point, a short report of the defendant. Tatyana, the floor is yours, please. Good afternoon, distinguished chairman, distinguished members of the Dissertation Board, and distinguished members of the audience. First and foremost, I would like to note that my research is devoted to some key issues of servitude, law, and its relation to the autonomy of will of the property owner and coercion. The relevance of this issue is related to the fact that immunity of property is key. Therefore, property owners have the maximum scope of rights. At the same time, property is not an absolute value, and its advantage also implies some limitations. In particular, civil law is quite often challenged with the necessity to use someone else's property by all sorts of parties. However, the owner may be unwilling to allow such parties to use his or her property. To solve these challenges, we need to find a best balance of interests of the third parties and the property owner. This, therefore, compels us to harmonize such categories as coercion and autonomy of will. On the one hand, when we are trying to limit the property right, we have to take account the will of all the stakeholders, including the owner. On the other hand, in a number of cases, when consensus is impossible between stakeholders, we have to impose limitation on the autonomy of will. Therefore, two types of limitations were identified. Those are limitations themselves and encumbrances. The limitations are not related to subjective rights, including granting the third parties some subjective rights to real rights to use someone else's property. Encumbrances provide real rights, including real rights of third parties to someone else's property, which are servitudes. Despite the fact that limitations and encumbrances differ depending on the legal systems, those are quite often not distinguished or distinguished incorrectly, which results in all sorts of negative consequences, dogmatic and practical ones. A servitude law displays such consequences when we are confronted by some routine challenges as well as in infrastructure settings. The relation of coercion and autonomy of will cannot solve some practical, technical issues related to the content of servitude, some subtypes of servitudes, and protection of servitudes. The correlation between autonomy of will and coercion is highly important to identify each of the aforementioned issues and to solve them. The tradition is insufficient because servitude law is theoretically underdeveloped and international practices are often overlooked. Therefore, it is undoubtful that a comprehensive integral research of coercions, autonomy of will, and servitude rights is necessary. Such a research has to look into integral historical, domestic, Russian, and international practices analysis. In that case, this would allow us to identify some relations, some dependencies, and to come up with the best set of legal practices. The dissertation is innovative because it relies on a comprehensive research of practical, doctrinal, theoretical practices in coercion and autonomy of will, thus providing answers to general and technical issues of servitude law and establishing some integral conceptual framework for the institution of servitude law. Therefore, may I present my key findings presented for defense. I decided to split those in two parts. Those are general issues on servitude law, coercion, and autonomy of will, including the following. Conclusion number one. The limitations and encumbrances imposed on property rights restrained the rights of property owners. Due to the fact that the scope of property rights are usually an imperative, without taking into account the will of the owner, without paying compensations or looking into some individual parameters of the property. The encumbrances are imposed as a disposition, which means those are imposed according to the will of the property owner, and those look into the individual parameters of the property. Conclusion number one. The scope of property rights can satisfy both an indefinite scope of parties as well as definite ones, for example, neighbors. Therefore, these limits can be expressed as prohibitions, obligations to the property. Third parties are not granted with some subjective real rights to someone else's property. Conclusion number three. De lege lata is a construct of public servitude, actually is associated with the limitations of property rights. However, legal tools to satisfy interests of parties involved should take into account not the imperative property rights, but encumbrances that imply a free disposition or both. Thus, public servitude is granted its very nature. Therefore, we need a coherent system of servitude types related to property. Conclusion number four. Depending on the form of property, including public or private property, and the procedure of imposing servitudes, free disposition or imperative or both, the dissertation defines the typology of servitudes according to the existing doctrine. We proceed not only from the private and public servitudes, but also include dispositive, imperative, or both servitudes, or the number of beneficiaries of servitude or servitude granters. Therefore, the typology of servitude is indeed renewed. This innovative typology of servitude takes into account the autonomy of will, which means that the free will in the property disposition is pivotal here. It has to take into account the individual parameters of property. Coercion in servitude law is something which is allowed in exceptional cases. Anyway, it has to take into account the interests of the owner. Moreover, such a typology of servitudes allows us to classify rights of a various scope of parties involved. The second set of my findings are related to some technical issues in servitude law and are associated with the autonomy of will and its coercion. Conclusion number five. The subject of servitude it can be both the owner of the property or the subject of the limited real right. This pertains both to the beneficiary of servitude and the servitude grantor. Conclusion number 6. Protection of servitudes can be done by a negatory litigation. Before the flaws in law are eliminated related to this issue, it would be reasonable to distinguish between to grant the beneficiary of the servitude the title to the property according to a relevant article in Russian Federation Civil Code. Conclusion number 7. Normally, servitudes generate a number of legal relations. One of them are real rights, the others are obligations. All of them are closely intertwined and are present when the subject of servitude changes. All the parties involved have to discuss and have to agree on that. Such a legal regime would allow us to classify servitudes as real rights, which are similar to qualitative obligations or obligatio procter rem. And finally, finding number 8, implementation of dogmatic constructs of negative servitudes is inadequate for Russian law because such a concept has alternatives for Russian. Those are civil agreements on obligations with some negative contents. However, if in the future the lawmakers would be sensitized to this typology of servitudes, such a concept can be useful to govern specific servitudes of specific type. In any case, a negative servitude has to be there only in case there is a necessity for such negative servitudes. It is also important whether the negative servitude implies the right to enjoy the property or it has some tools for its protection. Thank you very much for your attention. This is it for my part. Thank you so much. Are there anyone wishing to ask questions? Please ask questions only related to the report. No questions? Okay, then please be seated. And we proceed to the reports submitted to the Dissertation Board. So my report comes first. So we have overall 5 reports by Mr. Tuzov, Mr. Crespi, Mr. Kartsov, Madam Yemelkina, Mr. Zoller. And there was also one external report submitted by Professor Bevzenko, partner of Pepelayev Group. All of the reports were duly submitted according to provision 19 of the PhD awarding procedure of St. Petersburg State University, and they were downloaded to the St. Petersburg State University website. No commentaries or questions to the reports provided. So may I start with my report as a chairman of the Dissertation Board. The dissertation submitted by Tatyana Krasnova, devoted to servitudes, is an independent, creative, and comprehensive research. The relevance of this topic is obvious because servitudes appeared over 2,000 years ago, and today life is more challenging. Therefore, servitudes are not adequately reflected in Russian law. On the other hand, research overlooks servitudes, and therefore the author has to refer to various international sources and doctrines. The dissertation is methodologically and theoretically, empirically coherent. Servitudes are analyzed by way of the autonomy of will and coercion. The author has studied a vast amount of literature and research papers, including international papers. The author has analyzed regional and federal law, as well as court practices, so as to identify all the practical aspects of genuine servitudes and quasi-servitudes. The view of the author and the methodology is coherent. The innovative nature of this dissertation is reflected in highly relevant objectives. The dissertation is an independent research. It is very well argumented. It has a very well-structured logics. The findings are highly practical and theoretically important and have been tested at various conferences and by research papers. Many findings should enjoy support. For example, paragraph 2 of chapter 2, where the author shows how such areas are inadequate and illegitimate. The structure of the dissertation is in compliance with the objectives, the title, and the structure. That includes 3 chapters, 8 paragraphs, a conclusion, so on and so forth. However, there are some challenges and some scope for criticism. First and foremost, the objective, which says, and I quote unquote, the integral conceptual background of servitude law by way of looking into general and particular issues of servitude law, as well as the goals, in particular, quote unquote, identifying relevant and technical issues of servitude law, as well as providing answers to these questions. Well, those that do not reflect do not prove the scientific importance of this dissertation. Second, the originality of some findings is doubtful. This is true about finding number 1 and finding number 2. Establishing the limits to property rights and the very fact that this limits the autonomy of will of the property owner, both those are obvious things. The same is true on the very contents of such limits. In any case, the dissertation does not allow us to see anything original. Then on page 81, the author says that by looking at servitude rights practices, we can define servitude as the right for limited ownership and use of someone else's property. I don't see anything new here. Point 3, the first chapter of the dissertation. Here, the focus is disproportionate. Paragraph 1 takes 27 pages, including 20 pages devoted to Russian imperial law. The next paragraph looks into contemporary legal practices, which takes 10 pages only. And there is, I believe that this is indeed disproportionate, and the first paragraph could have been done in a shorter way. 4. Sometimes the text is too complicated and it's difficult to understand what the author means. This is true about the classification of servitudes in terms of the de lege lata and de lege frenda. It's not always clear when the author means de lege lata or de lege frenda, and what is the difference between these subtypes. Well, this is somewhat too heavy, actually, and too difficult to understand. Point 5. The dissertation is very well drafted, and the style is eloquent. However, there are some wordings, some phrases that are kind of not standard. This is true about non-normative acts, mentioned in brackets. Well, here we should do it differently. This is also true about the way the author quotes researchers for indicating the name and the patronymic instead of initials. 6. Sometimes some statements need some further argumentation. On page 14, the author claims that the collapse of the Soviet Union generated, kind of revived the servitudes. I believe that it is inadequate to justify servitudes by way of the collapse of the Soviet Union. Next, the author mentions that the servitude was generated as a result of the freedom of peasants. However, it is questionable whether servitudes were there at those times. And why should those be exactly related to this reform? On page 67, the author says that according to the existing doctrine, the servitude is the right for a limited use of someone else's property. However, this is true about personal servitudes only, whereas easements are established not in favor of someone else, but in favor of the property. Provision number 3, may I note that the de lege lata concept is closer to the limits of the property right, and hereby the defendant confirms that to satisfy interests of a specific scope of parties to enjoy someone else's property, what we need is a dispositive or dispositive and imperative framework. However, it is not clear from the contents of the dissertation why encumbrances on property rights must have such dispositive or dispositive and imperative tool. What is behind that? It is also important to look at finding number 6 on the protection of servitudes. To practically implement this provision, the defendant suggests an arguable approach by using fiction. So to observe law, as the dissertation says, it is wise to quasi-grant the beneficiary of the servitude with this right, according to a relevant article of the Civil Code of the Russian Federation, or to protect servitudes as stipulated by law. However, at the same time, the defendant criticizes a different approach when the beneficiary of this servitude is granted with the right, and it's not clear how those are different. However, the defendant sees some difference there. Terminology is very well done. However, it is discordant when the dissertation, the defendant speaks about the obligation, and real obligations. Then the defendant understands the subjective right and legal relations as synonyms. Is that indeed that way? Page 88, the author distinguishes between industrial servitude and legal or administrative servitude. However, in terms of terminology, this is not adequate, because those adjectives, I mean administrative and industrial servitudes, are equal in their meaning in legal settings. Next, the Actio Popularis is mentioned as the popular act. However, the dissertation says that it is populatory isks. I do not think that this is a correct term. Page 21, the defendant explains what rural and urban servitudes mean. However, this is something that is already there in Roman law. Page 35, the defendant refers to the Imperial Russian times, and here she mentions Alexei Kartsov as a scientist, as a scholar who existed in Imperial Russia. So how come? So all these critical remarks do not invalidate the dissertation and do not undermine the high value of this research. Therefore, the dissertation submitted by Tatyana Krasnova is an independent and original research, which is a significant contribution into law and is in compliance with all the relevant requirements, solving key challenges of legal practices. The dissertation is in compliance with the criteria and the requirements of the relevant decree on the PhD awarding procedure in St. Petersburg State University, whereas the author deserves to be granted the aspired degree of candidate of law in 12003 civil law, business law, family law, private international law, professor of civil law department, Mr. Tuzov. The next report is submitted by Gabriele Crespi, and may I turn it over to Gabriele Crespi. Professor Crespi, please, 10 minutes. Thank you so much, distinguished chairman. Daniel, well, may I address you that way because we know each other for quite a long. May I not read my report? And may I just say some summary about my impression of the dissertation. It is well known that servitude is one of the most ancient type of limited law. The Roman law of archaic epoch. Nevertheless, it is highly relevant today, and this makes the topic chosen by Tatyana Krasnova relevant. May I not pronounce your patronymic, Tatyana? Because in Italy we do not have patronymics, so it's difficult for me to say your full name. So relevance is there, right? Today, globalization, the word that I detest actually, has a trend to draw legal practices together related to real rights in various legal systems. So, and Tatyana looks into various legal practices. So this makes this research practically and theoretically significant. It is important to study these issues. In particular, it is important to study how autonomy of will of the property owner and the coercion or limitation of this will relate to each other. It is the limitation of the will that generates expansion of this right into civil regulation. This trend was less typical for Roman law. However, in the years to follow, the European civilization and its tradition manifests this trend indeed. Thus, the topic of the research is closely related to the relation between the principle of disposition and the imperative. What makes the dissertation innovative is that the defendant addresses and solves some issues that have been overlooked so far. I mean, practical and theoretical issues, as well as the defendant comes up with a number of groundbreaking conclusions that are included in the key findings. Well, these findings prove that the dissertation is logical, it is independent, and very well argumented. Academically argumented, I mean. I see that there is an analysis of a vast scope of court practices that is highly relevant, highly important for me, because I'm not actually a Russian lawyer and scholar. So I'm not familiar with these practices, or little familiar with those. Moreover, the defendant uses the historical and comparative methods, which is always relevant today, because without being able to compare to our past, we cannot speak about trends. I cannot analyze how things are changing. Well, I have some specific technical things to highlight. So I found out that the results of this defense, this paper, were proved practically and implemented in research articles, at research conferences, and in class, actually. So those have been discussed by fellow colleagues. For example, the finding that in Russia we have to implement the primary servitude as a subjective law is related to the Roman revival of Actia Popularis, which is available to each member of this indefinite scope of stakeholders. The structure of the dissertation is in compliance with the objectives and the goals identified by the defendant. The list of sources and the bibliography is highly exciting and valuable. Well, my general positive impression, distinguished chairman, does not prevent me from voicing some minor flaws. Probably it is actually my misunderstanding of Russian, because some words, some phrasings were inarticulate to me. Those were difficult to understand. Well, I don't have time now, but I do see that more questions are to follow, right? So I may ask more questions, right, to the defendant. I will have such an opportunity, right? Yes, you will. Okay. Well, I can say that thus I can say again and reiterate my idea that the dissertation provided by Tatyana Krasnova is an independent and a valuable scholarly research This dissertation is integral, structurally integral, it is original, innovative, and demonstrates a personal contribution of its author. Therefore, it is in compliance with the requirements to dissertations submitted in compliance with the academic degree of candidate of law. And lastly, and Mr. Chairman, you also mentioned some degree, right? Yes, exactly. The dissertation by Tatyana Krasnova is in conformity with the requirements stipulated in the decree as of September 1, 2016, number 6821/1 on the PhD awarding procedure in St. Petersburg State University. And finally, I wish to Tatyana to broaden the scope of her research and to look deeper into international legal systems, in particular those related to common law and Chinese law. We can add up Chinese law as well, because China is now highly excited about Roman law and the relevance of some provisions of this law. Thank you so much. Thank you so much, distinguished professor. May I now give the floor to Mr. Kartsov, Alexei Kartsov, Professor Kartsov. Good afternoon, distinguished colleagues. The relation between imperative and disposition elements in law are a key finding, both in jurisprudence and in other applicable sciences. Therefore, the research by Tatyana Krasnova looks at the dichotomy of those two components, thus making this research relevant and original. The fact that this issue has been overlooked largely by academic tradition contributes to the relevance of the research. Well, anyway, this has been overlooked in Russian legal tradition and scholarly tradition of law. Therefore, the defendant has successfully delivered on the objectives and goals. The context of the dissertation is in compliance with the title, and the structure is in compliance with its contents, thus reflecting the goals and the objectives. The categories of disposition and autonomy as well as the categories of coercion and autonomy of will, are described very logically and integrally. What makes the dissertation so strong? Primarily, those are the knowledge of Russian and international doctrine. The dissertation is very well thought. The defendant arrives at, indeed, groundbreaking evidence-based conclusion, thus establishing an integral conceptual framework. Both some technical conclusions as well as the general conclusions are very well articulated and are in compliance with the results presented for defense. The dissertation includes analysis of all sorts of legal practices, domestic and international ones, as well as litigation practices. All the findings presented for defense generate no doubt. Those are groundbreaking and solid. Well, apart from that, I would like to say that this dissertation is a civilization research. It looks into highly relevant issues. The defendant has successfully established a balance between the civilizationary intentions, for example, disposition and imperative modals on the one hand, and on the other hand, the scrutinized analysis of lawmaking context. I have to mention that the balance between private and public interests, legal interests, is something which is typical of St. Petersburg law scholarly tradition. Tatyana, therefore, follows into the steps of her senior colleagues, which makes it highly advantageous. May I note the approach to the analysis of the approaches by Gins, one of the key lawyers of Russia. The dissertation is very well thought, and it also provides some historical background. A number of issues in servitude law, for example, a lack of distinction between neighboring law rights and servitudes, have not yet been articulately expressed in Imperial Russia, and this is something for us to deliver on today and to correct. I cannot but agree with the author that always do we have to take into account the historical background so as to justify risks and the valuability of distinctions. This retrospective framework, as well as doctrinal approaches, are very well justified and required. I believe that such a view clarifies some particular features of legal practices, which sometimes or quite often results in dysfunction. Primarily, here I mean the regular servitudes or irregular ones. However, the so-called what used to be land plots and what used to be not a servitude but a privilege, mutatis mutandis, is still there. Another advantages, tangible advantages, is that it is critical, always, but not polemic. An exciting suggestion justified by Tatyana Krasnova relates to improving the reglementation of legal relations in civil law. Another thing which is exciting is the economic analysis of law and right. Therefore, the notion of paying for servitudes is highly relevant in this respect. May I not focus on the advantages now and proceed on to some critical points. First, although the theory and the methods are relevant and well tailored to methods, I have a question. Integral legal practices and the scholarly paradigm mentioned by Tatyana Sergeyevna, in what way were those used? And how have they promoted the achievement of goals? Next, the coverage of an important issue related to the limits of servitude encumbrances related to property laws in privatization is kind of too haphazardly covered. And I think that the defendant may have a wish to expand on this. I have some doubt on the bibliography. It is doubtful that the institutions of Guy and Digest of Justinian are monographies or textbooks. But those are not university textbooks in our contemporary understanding. The same thing is true about some legal acts of Russian Federation that date back to the 19th century, or the entire scope of the Russian Empire laws that are labeled as effective rules and regulations of the Russian Federation. Model laws of the Interparliamentary Assembly of the CIS are not international documents, are not in acts or regulations. Those are just international documents that include recommendations, but not more than that. Equally, restatements of the law drafted by American Law Institute are not rules and regulations, legal rules and regulations. Those are just recommendations that reflect the consensus in national jurisprudence related to specific areas of law. And lastly, we cannot deem the statements issued by anti-monopoly bodies as judicial practices. So this does not actually invalidate the worthiness of the dissertation. This opens up further horizons for further improvement and do not invalidate the results. Overall, the dissertation is an independent book which is groundbreaking and has an academic importance. The results have been very well implemented at roundtable seminars, international conferences, and fora. May I note that Tatyana Krasnova's paper is very well known to legal scholars. All the findings are very well echoed by the presentation, by the publications. Therefore, I have to state that the dissertation submitted for defense contains solutions to some burning issues, burning challenges of jurisprudence, and is in compliance with all the requirements stipulated under the decree on the PhD awarding procedure in St. Petersburg State University, approved as of September 1, 2016, under the number 6821/1, whereas Tatyana Krasnova deserves to be awarded the aspired degree or academic degree of the candidate of law in the subject 120003, civil law, business law, family law, private international law. Thank you very much. Professor Kartsov, may I now turn it over to Doctor of Legal Sciences, Docent Yemelkina. Distinguished members of the board, distinguished members of the audience. The dissertation by Tatyana Krasnova is highly relevant. Over the last decade, Russia has been presented with passionate discussion on law reforms. However, today, as we all know, only one real law institute has been reformed. This is servitude. This is not by chance. Today, Russia has been confronted with other phenomena. Therefore, the government feels more comfortable to establish a public servitude. However, this issue is relevant not due to public servitude only. Practices show that a private servitude is also important. Recently, the Supreme Court of the Russian Federation has approved a review on judicial practices related to debates in servitude rights. Therefore, in the context of this event, may I state that Tatyana Krasnova is one of the pioneers in looking into the issue of servitude law. Today, it is suggested to review methods of legal regulations of real law. Therefore, the fact that we have to investigate servitude in terms of disposition and imperative is highly relevant. I should note that the dissertation is very well structured. The author's idea is to show how will and coercion are related in servitude law. Personal right is important. Neighbor's right is defined for the first time. Real rights as well. One of the advantages of this dissertation is that Tatyana Krasnova looks into both Russian and international sources. A valuable aspect is the legal basis, because the defendant looks into judicial practices and court rulings related to servitude law. So I'm not going to list all of those. What I find most valuable is finding number 1, finding number 4, finding number 5, as well as a broad scope of other highly striking conclusions that are valuable. This is indeed a research-intensive dissertation. It was easy to read, and every page gave some ground for further contemplations on the most relevant legal issues. However, some findings need further enhancement. I would like to split my recommendations in two parts: the general aspects and some technical aspects. Well, comparative method is over-focused on Anglo-Saxon and American legal practices, whereas domestic practices are overlooked, or continental practices. Such an argumentation where the real rights, American law, are based on continental law, or the legal practices that are unknown to domestic Russian practices, could be inadequate and could undermine the general conclusions. For example, page 113, 114, the defendant justifies the similarities between servitudes in German model and the Anglo-Saxon model. However, there is no reference to German legal acts. Next, there is some imbalance in studying the servitude law, and the autonomy of will is over-argumented, over-supported. In this respect, some conclusions related to the numerous clauses principle are inadequate or too weak. For example, dispositions, free disposition as an obligatory component of servitude. Third, the author is trying to be too original and thus is trying to calibrate the existing law, including public law, by the classical legal doctrine. And now some technical aspects. Property rights to land belonging to some indefinite scope of persons, and though their inclusion into the category of subjective, limited, real right. Well, this generates a lot of questions. I should note that the property right is not limited. So it has to be split in two types. The first one does not provide the rights to the property, and the second type, the encumbrances, imply an independent, limited servitude rights to the land. Therefore, my question: why is the author looking for some scholarly justification of this distinction? The introduction of the approach developed by Fleischitz is inadequate to support the presence of subjective real rights. On page 107, Tatyana Krasnova writes that each of the entities is entitled to an subjective real right to someone else's property. I should highlight that the authors of such approach analyzed this theory in an absolute legal relation, where a non-limited number of subjects or third parties took an obligation not to violate the property rights of a specific entity. The implementation of this idea by Tatyana Krasnova would make the real rights pertaining to an indefinite scope of persons. If a non-identified scope of persons have a right of servitude, then those has to be registered. So if those have a subjective real right, then the scope of such rights is not limited. In that case, the proprietor of land will have to study the encumbrances and their contents, which would not promote sustainability of civil practices. Further argumentation is necessary to prove finding number 3, where the limitations to property rights, as stipulated by the author, grants the possibility to enjoy someone else's property right outside the subject servitude. Moreover, referring to international practices, Tatyana refers to similar servitudes in American law. However, what is overlooked is the fact that the similarity between Russian legal practices and German or other continental legal practices imply such a construct of legal Servituten in German, which implies some encumbrances or coercions imposed on the personal right. On page 104, I would like to argue the fact that the legal nature of real rights is arguable, and therefore, however, the author does not provide any argumentation of these statements. And yes, indeed, it is. I believe that legal nature of real rights is arguable, and this is a matter that has been discussed quite long. To some scope, I may agree with Tatyana, because there used to be arguments and negotiations that date back to the 19th century. And here I should note that a meticulous analysis of this discussion is referred in the paper by a German scholar, Dunker, dating back to 1837, where the scholar looks at all sorts of theories and arrives at a conclusion. This is something which belongs to law. Therefore, we can say that real encumbrances were well known to Russian practices and Russian imperial practices as well. Therefore, we cannot substitute those by real obligations that is present in American legal practices. This is something which is which would be inadequate here. Okay, may I wrap it up? So all these critical remarks do not invalidate the worthiness of the paper. The dissertation is fundamental. It is done on a very high scholarly level. Those do not prevent me from assessing the dissertation as a highly valuable and positive. Therefore, the dissertation by Tatyana Krasnova, Coercion and Autonomy of Will in Servitude Law is an independent creative research, and therefore it contains key solutions to burning contemporary challenges. Therefore, the dissertation submitted by Tatyana Krasnova under the title Coercion and Autonomy of Will in Servitude Law is in compliance with the requirements stipulated under the Decree 6821/1 as of September 1, 2016, PhD awarding procedure in St. Petersburg State University, whereas Tatyana Krasnova deserves to be awarded the aspired degree in of candidate of law in the subject 120003. May I now give the floor to Professor Zoll to voice his report. Thank you so much, distinguished colleagues. I will speak in English because I have made my report in English, but I will participate in the discussion in Russian. Итак, предмет данного исследования. Сервитудное право это является новым концептом в современной юридической традиции и обладает очень гетерогенной природой и фактически находится на границе между правом собственности и правом и правом обязательства. Именно поэтому встает вопрос о содержании сервитудного права. В диссертации также рассматривается другая проблема, которая касается систематизации различных обременений, налагаемых на владельца. Прежде всего, диссертант рассматривает различные варианты различных обременений, которые имеют отношение к владению недвижимости. Госпожа Краснова также анализирует различные обременения, которые она квалифицирует как права на владение недвижимостью и как сервитудное право. Основным вопросом, который возникает в диссертации, является гибридная структура сервитудного права и наличие в нем каких-то обязательных и опциональных элементов. Диссертация состоит из 3 глав. Первая глава рассматривает некие общие вопросы, касающиеся сервитудного права. Предлагается очень обширный исторический контекст. Эта часть помогла мне понять развитие российского законодательства. То есть для меня эта часть была очень полезная. Очень полезен был вот этот исторический экскурс для того, чтобы понять, как развивалась российская правовая система. У меня есть некоторые сомнения, которые касаются, собственно, структуры диссертации. В особенности мои сомнения принадлежат второй части. Здесь первый параграф посвящен международным практикам, а вторая часть посвящена именно российским правоприменительным традициям. И эта часть была бы для меня наиболее важной. Однако эта часть достаточно сужена и занимает, в какой-то степени, мне кажется, она недостаточно раскрыта. Самой основной частью работы является третья часть, но при этом первые 2 главы, такое ощущение, в отношении первых 2 глав у меня создается ощущение, что они доминируют в диссертации, потому что их объем гораздо превышает объем 3 главы. В целом, я считаю, что диссертация госпожи Красновой обогащает существующую догматическую правовую традицию. Это не компаративное исследование по своей сути, однако диссертант пользуется сравнительно сопоставительным и историческим методом при анализе материала. Здесь же, наоборот, анализ международных правовых систем, иностранных правовых систем помогают нам обогатить наши взгляды на сегодняшнюю российскую реальность и поддержать выводы, которые выдвинуты диссертантом на защиту. И здесь нет никакого противоречия. Мне кажется, что вот эти 2 компонента, иностранный компонент и российский компонент, они находятся в очень хорошем балансе. Также использование доктринальных источников и других правовых источников юриспруденции оправдано. Используется также и исторический метод, он используется очень осторожно и во многом объясняет выдвигаемые на защиту положения. Это действительно настоящее научное использование исторического метода, а не какое-то наукоподобие или наукообразие. Для меня самой главной была 3 глава. Здесь обсуждается место сервитудного права в схеме частного права. Часто очень сервитудные права определяются как вечные права и при этом отличаются от обязательственных прав. Здесь также обсуждаются вопросы защиты сервитудных прав. То есть, таким образом, диссертант имеет более консервативные взгляды и придерживается консервативной концепции данной доктрины. Сервитутные права представлены как правовой объект, имеющий очень сложную структуру. В этой связи они имеют различное количество, они предполагают наделение их участников различными правами. Можно задать вопрос, есть ли различие между правами проприетария или обязательствами? Остается ли релевантность принципа numerus clausus? Если особенно учесть, что на сегодняшний день правовые взаимоотношения становятся все более и более сложными. Это только теоретический конструкт, или здесь есть и практические моменты? В целом, госпожа Краснова говорит о том, что на сегодняшний день отсутствует необходимость включения отрицательных сервитутов в правоприменительную российскую практику. А следовательно, если речь идет о сервитутных правах с ограниченным содержанием, то тогда это в полной мере соотносится с пониманием сервитутных прав как вечных прав. Отсутствие широкого понимания сервитутных прав и их точного определения имеет существенные последствия для контрактного права, контрактных взаимоотношений. Но здесь очень четко обозначены правовые системы автором. Здесь хорошо представлена аргументация в сравнительном аспекте. И именно в связи с этим госпожа Краснова предлагает утверждение о том, что отрицательное сервитутное право иногда может все-таки использоваться российскими правоприменителями. Также очень широко освещаются международные практики, касающиеся сервитутного права. Например, диссертант обращается к польскому праву, к германскому праву и рассматривает понятие сервитутного права в самых различных контекстах. Несмотря на то, что это все-таки иностранные системы, такой анализ, широкий анализ в высшей степени оправдан. В российском, например, законодательстве существует более жесткий подход к установлению сервитутных прав. Для диссертанта рассмотрение сервитутного права и, в частности, предиального сервитуда в качестве вечного права, в общем, является самым основным вопросом, и отсюда практическая значимость работы. Предлагается очень хорошая типология сервитутных прав. Все эти соображения снабжаются очень хорошей аргументацией. Я полностью согласен с пониманием того, что здесь речь должна идти именно о правах, а не о владении собственностью. В целом я должен заключить, что диссертация Татьяны Сергеевны Красновой принудительности и автономия воли в сервитутном праве на изыскание ученой степени кандидата юридических наук по научной специальности 12.0003 гражданское право, предпринимательское право, семейное право, международное частное право соответствует требованиям и критериям, установленным приказом от 1 сентября 2016 года номер 6821/1 о порядке присуждения ученых степеней в Санкт-Петербургском государственном университете. А ее автор Татьяна Краснова заслуживает присвоения ученой степени кандидата юридических наук. Thank you so much. May I now read out the external report submitted by Roman Bevzenko. The dissertation covers a highly relevant issue. It is highly valid. First and foremost, in terms of the analysis of legal acts. The author of the dissertation looks into all sorts of servitudes and establishes a very solid framework on how to interpret those. Just some comparative mention, just some point of criticism. The property law is sometimes deemed archaic and feudal. All the servitudes described by the author also establish a highly complicated system that reminds me of land law in England. Possibly this system reflects the new Russian feudalism, something which is going on between Russian Federation and its subjects today. I mean, the scornful treatment of the government to private land property, this allows me to say that the right to property in Russia is not similar to the right to property in Western states. However, the meticulous approach of the defendant is also a disadvantage of the dissertation. The language is very complicated. It's not easy to read. But the author of the report says that it is only due to the subject of the research. The bibliography is indeed impressive, covering all contemporary works in servitude law. The author is very well trained in court practices, and now may I proceed to discussing the contents of the work. The author of the report agrees with the key conclusions, primarily the fact that we have to distinguish between limitations of the scope of property rights, legal servitudes, and private servitudes. The author quite often refers to the expression of imperative and dispositive encumbrances, or even both imperative and dispositive encumbrances. However, it is not clear what does the author mean here. It would be beneficial to provide a definition of these terms. Otherwise, one has to make guesses. The expression, the type of property, an obsolete term is also used here. What's the reason behind that? The author said that coercion in servitudes is something which is exceptional. However, we have to analyze the register and the existing practices, including the data provided by the Ross register. Next, the author says that servitudes are rooted as in the objective necessity. This is true only for servitudes that are imposed as a result of court ruling forcefully. Otherwise, the Ross register will have to clarify with parties whether there is an objective necessity for a servitude, which is inadequate and contradicts the very nature of things. However, the defendant claims that servitudes being imposed by court ruling is exceptional. Therefore, an only type of servitude is the forceful servitude, the coerced servitude. So it's not clear. There is a contradiction, an obvious one. Overall, the author should be more focused on urban law. Servitudes are an archaic pattern of social and legal practices. It is only functional for uncivilized societies, whereas in developed societies, this is already solved by public law. Therefore, the most exciting thing today in servitude law is the way it functionally relates to public law. Next. The next conclusion is can be avoided. I mean, the conclusion saying that the public law provides a number of mechanisms to ensure protection of landowners. However, then the abuse of autonomous will is excessive. Next, the author favors historical or comparative or dogmatic analysis. However, today in jurisprudence, we more often address sociology, economy, or some other interdisciplinary aspects. And here, the defendant refers to the research by Karapetov. Going back to dogmatics, there is one more miss. When we discuss abuse of forced servitudes, I believe it is not justified to compare those with dogmatic abuse of obligations. Here I mean the freedom of agreement and its limitations. In particular, the doctrines and court practices, as well as the rulings of the plenary Supreme Court. One of such criteria is the interest of third parties. I believe that such a distinction is pervasive, and it is true for all fields in private law. Well, if you take the situation when an owner does not allow the neighbor to take water from the well which is located on his land, so how should we rule this situation? So I would like that the defendant stipulate here in more detail on what she means. I very much fancy the position of the author on imposing servitudes. However, what does it mean, a court ruling on coercion of servitude? It seems to me that our chapter 3 is outside the overall context, where the defendant looks into various subtypes of servitude law, which has no relation to coercion of servitude. We should keep in mind that the volume of this chapter is indeed significant, which means that the defendant is in favor of the less radical servitude law. The protection of servitude law is a little bit inarticulate and evasive. Here the author pays a lot of attention to criticism of her colleagues. However, I do not think that all those critical remarks are valid. And by the way, How does the view of the author relate to the fact that servitudes have to be acquired by way of the longer time frame? Well, according to the acting law that covers the negative claims, we do not have such practices. And another question relates to the statement that according to the acting right on on property acquisition, can we imply negative servitude here or not? Overall, the dissertation by Tatyana Krasnova, under the title Coercion and Autonomy of Will in Servitude Law, submitted in compliance with the academic degree of Candidate of Sciences in the subject 120003 Civil Law, Business Law, Family Law, Private International Law, is in compliance with all the requirements stipulated under Decree 6821/1 as of September 1, 2016, whereas Tatyana Krasnova deserves to be awarded the aspired academic degree of Candidate of Law in the above-mentioned subject. Roman Bevzenko, Professor of the Russian School of Private Law. Thus, we have exhausted the list of reports. May I now give the floor to the defendant to provide her replies to the critical remarks of the members of the dissertation board. Please, the floor is yours. Thank you. First and foremost, may I extend my gratitude to the members of the dissertation board, as well as Roman Bevzenko, for their elaborate reviews. Due to the fact that I have a limited time frame, may I join these questions together into specific sets, right into blocks. Well, as for some technical flaws, corrections, misprints, using extra or failure to address some textbooks or papers, well, I accept all of those. As for the method, the conclusions include the integral legal science. The integral concept implies that it is not a phenomenon of the society. It is not a fact. It is not a relation. It bridges together all of these aspects, and always it is something more than all those taken together. So therefore, it includes various approaches to law, and it should not be dogmatically biased. If we look at policies, those imply regulatory methods. The analysis of law in terms of economics or morality, this is a different thing. As for my dissertation, this means that I was guided by both dogmatic jurisprudence, but also by economic, political, and socio-cultural understanding of the function of an owner of a property. Such an approach allowed me to formulate an integral concept of contemporary servitude law, including the civil relations, economic efficiency, rationale, and faith. I cannot but agree with the fact that my contribution is minor, and I'm at the very beginning of my future endeavors. Further on, I will be adapted to a more radical approaches and a deeper approaches. For example, historical method allowed me to ensure integrity of legal tradition. Thus, a comprehensive historical analysis allowed me, by referring to Imperial Russia, to demonstrate how important it is to distinguish between limitations and property rights. This allowed me to come up with some key findings and formulate some key conclusions, and then proceed on to studying the modern types of coercions related to property rights. As for the comparative method, I studied equally both Anglo-Saxon tradition, English and American law, as well as continental law, Netherlands, French, German, Austrian, Italian, Dutch, post-Soviet Russia, as well as mixed legal systems such as Scotland, South Africa, Louisiana. On the other hand, the major scope of bibliography is in English. However, those are works by renowned and prominent luminaries and experts in their national scholarly legal traditions. As for the structure of my work, I study this issue step by step, so I start from general issues, proceeding on to some technical issues of encumbrances, coercions. Such an approach allows me to identify the contents of servitude, then to discern it from some border phenomena, to identify subtypes of servitude, and then address some technical issues of servitude law. As for technical issues of servitude law, most of them are indeed are the focus of my dissertation. Here I should say that the correlation between the autonomy will of the owner and coercion are highly relevant for each of those. In my approach, I also cover general scopes of servitude law, Chapter 1 and 2. Without those, the basis, the very fundamental basis and roots of my dissertation would have been missing, and I would have failed to focus on some minor details that are key for the development of contemporary servitude law. The questions related to the definition of what a limitation is and how do private and public aspects relate within the scope of servitude law. Here I should note that servitude law, on the one hand, covers autonomy of will, coercion, and impossibility of interference, voluntary interference. On the other hand, it observes the principles of faith and equality, and those do not contradict one another. I believe that lawmakers, usually to make those coherent, has to impose some limitations. I believe that these limitations are indeed crucial because those are rooted in one and the same grounds. At the same time, those limitations are somehow interpreted due to the fact that they are implemented by legal practitioners and are industry specific. So therefore, the private freedoms and the arguments, debates around the limitation of private freedoms is a burning issue even today. Here may I refer to Mr. Karapetov, who says that we can speak about freedom, freedom of property, freedom of agreement as a presumption. Fundamental rights and freedoms of people fuel a lot of discussion, and those have to be promoted by encumbrances, by imposing limitations. When we speak about freedoms, we have to speak about limitation, and therefore the agreement between parties is an agreement, it is a deal, whereas a servitude, it is an introduction of encumbrance onto the property right as an imperative or a disposition, so as to serve someone else's interests. And this is something which pertains to the freedom of will and inacceptability of interference. Generally, we have two types of constraints. Those are encumbrance and limitation. In my dissertation, I distinguished between these two types of constraints by focusing on the subjects, provision 2, provision 5. Therefore, the novelty of provision 2 is that I suggest a specific criteria on how to distinguish between limitations and encumbrances, including the fact that the limits of property rights generally do not imply limited right to enjoy someone else's property. By imposing these limitations in favor of indefinite or definite scope of parties would promote sustainability of civil legal interactions. However, imposing such limitations cannot solve all the issues, all the challenges, including challenges that are related to infrastructural projects. Therefore, we need a servitude law. And to this end, I cover these issues and identify their function and role in relation to servitude law. Moreover, urban construction laws usually solve some specific issues of servitude law implementation by looking at what should come first, what should come second. It is also there to identify specific areas of specific functions. I believe that the scope of my objectives identified in the dissertation would be does not include the urban construction law. According to the existing doctrine, servitude is identified as the right to use someone else's property in favor of some entity, some specific entity. And hereby, we identify specific subtypes of servitudes. Whereas the term a definite entity does not mean that we mix up real and private personal servitudes. A specific person is not an entity A or an entity B. It is whatever entity there is. Therefore, I note that I'm addressing only to real servitudes, but not personal servitudes. The dissertation identifies servitudes as the right for limited use of someone else's property, proceeding from the form of property, the scope of servitude beneficiaries, and therefore I suggest to identify some subtypes of servitudes. If we compare de lege lata and de lege ferenda, then it is obvious that those have different scope of subjects, as well as the different relation between coercion and autonomy of will. And this is covered in chapter 2 of my dissertation. The key idea is to have some innovative, some revised structure of servitude rights, and to identify priority of voluntary distribution of property rights, and to promote the concept of agreement between various stakeholder parties. The question on servitudes in favor of indefinite scope of entities. The analysis of existing law and judicial practices show that the existing relations when an indefinite scope of parties want to enjoy someone else's property show that those practices are not flawless. Therefore, what we need is reasonable legal practices to satisfy claims of indefinite scope of parties, enjoying the right to a limited use of someone else's properties. And this is where not private but dispositive or dispositive and imperative servitudes have to step in. And therefore, my revised typology of servitude rights, including private industrial public servitudes, and so many others. There is also a number of theoretical and practical aspects which are listed in my dissertation. I'm not going to focus on those. I, however, focused on the practical aspects. When there is a necessity to provide private property to a limited scope of indefinite entities for use, then we are confronted with the issue of how reasonable this practice is. On the one hand, there are imperatives. On the other hand, there are dispositive and imperative encumbrances and servitudes. If we look at the first issue, then we find out that there is a significant limitation without looking into the autonomous status of such an owner, without agreeing on the terms, and without referring to individual parameters of the property. If we look at the other option, then such a practice implies that these entities cannot enjoy the property in a private and legal scope, whether there is an unbiased necessity for such use or not. If we look at the other option, then we would avoid these flaws and inadequacies. Servitudes would not save the situation. In this case, what we have is a mixture of the scope of property rights. Madam Krasnova, you have to wrap up. For example, the regulation of private property by way of servitude law, in this case, we cannot implement that if we are speaking about public servitudes. This is just a minor scope of the issues that I wanted to cover in my response. Well, if necessary, I have all the answers in writing and I can present those. Thank you very much for your attention. Thank you. Now, may I address all those present here, whether they would like to take the floor and to make a contribution to the dissertation, related to the dissertation and the defense procedure. Please be brief. No one is willing to take the floor. Good. If no one is willing to take the floor, so there is nothing for the defendant to provide replies, may I now turn it over to the scientific supervisor, Professor. Thank you very much. So we are about to violate the time limit, so I'll be very brief. May I say that the very issue of servitudes is limitless. Of course, some aspects that are worthy could not be covered within just the limited scope of a candidate dissertation. So I believe that Tatyana will invest all her life to analyze servitude law and rights. However, I believe that the challenges identified in this research and the objectives of this research are very well stepped up to. The bibliography is vast and allowed to analyze this topic from all sorts of angles. Therefore, this dissertation has a huge practical horizon. Therefore, may I urge everyone to grant her the aspired academic degree. Thank you very much, Professor. And now 5 minutes break to discuss the issue of whether Madam Krasnova has passed or failed. Please, I urge all the members of the audience who are not members of the Dissertation Board to leave the room. You will be invited once we have finished, we have made our decision. So broadcast is over, or is interrupted for the time of discussion.
Заседание продолжается. Прошу включить звуковое сопровождение.
May I resume the session? We move on. Please switch on the broadcasting and please ensure that broadcasting is there and that it works well. So now we put on open voting the question on awarding Madam Krasnova with the expired academic degree. This issue is subject to open voting by name. May I remind you that the decision is valid provided that over 1/2 of the dissertation board, but not less than 2/3 of the dissertation board composition vote in favor. Provision 1 to the relevant decree. Member of the dissertation board, Professor Gabriele Crespi. Please, your vote. I'm in favor. Next. Please, Professor Kartsov. I'm in favor. Madam Yemelkina, I'm in favor. Frederick, I'm in favor. Well, me too. I'm in favor as well. So, out of the 5 members of the dissertation board, 5 members have voted in favor, against none, abstentions none. Therefore, the decision to award Tatyana Krasnova with the expired academic degree of Candidate of Sciences in Law in the subject 120003 Civil Law, Business Law, Family Law, Private International Law is effective. Madam Krasnova, your concluding address. I would like to extend my gratitude to everyone, to members of the dissertation board for their contribution, for participation. I extend my gratitude to my research supervisor, to members of the department, Madam Raskazova, Mr. Rubarov, Mr. Tolstov. I extend my gratitude to Mr. Gromov. Well, maybe I could not mention the full list of those who have supported me, as well as my colleagues, Mr. Karapetov, Mr. Bevzenko, Mr. Bagayev from Moscow, and of course, my huge gratitude to my parents, Mr. and Madam Krasnova, my husband Ivan, my friends, and all of you. Thank you so much. The session of the dissertation board is now adjourned. Thank you very much for participation. You can congratulate our young candidate of law. Please switch off the broadcasting. Thank you.